Afternoon, Your Honor. The matter before the court this afternoon is the case entitled State of Vermont versus Christopher LaFountain, case number 24 AP 314. Representing the appellant, Christopher LaFountain, is Jordan Handy, and representing the appellee, the state of Vermont, is Maria Byford.
You just froze after you gave Mr. Handy's name.
Can you hear me now?
Now I can.
Okay. Representing the appellee, the state of Vermont, is Maria Byford.
Okay, thank you. Can you all hear me okay?
Yes, Your Honor.
Okay.
And your video is working.
Okay, good. Thank you. And thanks for participating today remotely for this bail appeal. Please do flag me if you're not hearing, because the view I'm getting is a little jittery. So I'm hoping this works okay. So I'll hear first from Mr. Handy. And there's one thing I just want to mention before you give me your argument, because I think it might be helpful. A 1J review under 7556D is really a de novo review, meaning that the court, makes a decision anew about the facts, the law, and the conclusion of the case. The briefs, the memos by both of you really were arguing about decisions the trial judge made and why there was error. And I just want to be clear that it's not my position at this point to be deciding whether the court below erred. It's a fresh look at the whole facts, evidence, and conclusions myself. So I just want to make you both aware of that so you can tailor your arguments accordingly. So go ahead, Mr. Handy.
Yes, Your Honor. So basically, I would like to say good afternoon, Justice Carroll. Thank you very much for having me here. I'm attorney Jordan Handy. I'm representing Mr. LaFountain, the defendant in this case. Your Honor, I would like to reserve probably about 4 minutes for rebuttal, and I will probably stop myself when I feel that that's the time.
Okay.
We're appealing the court's holding that the defendant was be held without bail under 7553A, Your Honor, for specific reasons. One is that I feel like the court misconstrued a standard when it came to the condition for adult, that their responsibility, the court specifically said on page 56 of the transcript, the court is not convinced that they would be able to stop him if he was to really make an attempt to follow through on his plan of action. And he's talking specifically about the defendant and whether or not the condition fours, and there was 3 condition fours brought up to the court, Your Honor. His ex-wife, who's a nurse, his brother, who is a correctional officer, and his lifelong friend, all who live in about 2 to 3 miles from the home. And even the court said that these are all satisfactory, responsible adults. And even the state said in their closing that that the 3 adults that we provided were impeccable members of society with no criminal record. And the court said that they were worried that the responsible adults would not be able to physically stop my client from violating his conditions of release, which is not the standard. The standard is that a responsible adult's job is to call the police when they know that a violation has been committed. Because it wouldn't make any sense for the court to apply a standard in which they had to be able to physically stop someone. The court would then be asking people then to physically restrain people, and that's beyond the scope of what a condition 4 is meant to. The condition 4 is supposed to be able to reasonably provide reviewing and inspecting and following the conditions of release, making sure those are done, making sure the curfew is followed. And those are the type of things that it's supposed to be doing. And the court relied heavily on that as a reason of why they denied the 7553A or denied him being released and saying that there were no conditions of release that could be used. That it just doesn't make any sense under all the other times that I've done bail review hearings. We've done condition 4. That's why we just talk. One of the things that the judge usually goes over is saying, listen, you have a responsibility to know the conditions of release, and if they violate that, you must report that immediately. I've never heard a judge say, well, you must stop them from violating, because that would be unreasonable, and I don't think it's where the court would want us to go with condition 4. Your Honor, the other issue that I'd like to bring up is the trial court seemed to base a lot of the evidence or the reasoning behind why they wanted to hold him was because he had a history of threats and of suicide, based off of the victim's affidavit. But if you look at the victim's affidavit, which is State Exhibit 2, Your Honor, nowhere.
Attorney Handy, I want to ask you something about that.
Yes, Your Honor.
That affidavit was admitted below with no objection.
I know. I was not the judge. Oh, I'm sorry.
And I know you weren't the attorney at the time, but how can I consider that argument when it was not raised below and the evidence has been admitted?
Because the judge specifically stated in his closing, when he was doing his holding, that he was not going to rely on any hearsay statements that had come through. He specifically said that, and then relied on this, which is basically now a hearsay statement, because,
I guess I'm asking you more about the legality of it, the potential argument that defendant waived that argument by not raising it below.
Well, Your Honor, I think that Your Honor, I think that when they were going through these issues, that the attorney during the time was maybe misunderstood what was allowed to come in and what wasn't allowed to come in, and failed to make several objections. I conceded that during this, that there was many objections that probably should have been made that weren't made, but those errors, even regardless, the judge said that they weren't going to be accepting those hearsay admissions. And if the court's looking at the statement now, and you're looking at this de novo, and you're going to be considering this blank and looking at it, then you should be looking at this and say, well, there's no attestation to it being a truthful statement. There's nothing that says that if it's not a truthful statement, that you're being punished under the pains and penalties of Vermont's perjury laws. Additionally, its notarization is completely incorrect, Your Honor. One, it's dated for March 11th, 2024, and then the victim signed it 10/11/2024. Plus, the notarization just on its face is faulty, because notarizations, Your Honor, under Title 26, 5367 says that it needs to be signed and dated, identify the jurisdiction in which the notary act is performed, that's not done here, contain a title of the office of the notary, not done here, and indicate the date and expiration of the officer's commission, which is not here. So if you don't have these hearsay statements and all of these statements are taken out, Your Honor, you're just basing it off of the trooper's testimony, and that's not enough then to bar my client being released under 755 I'm sorry under the hold without bail statute 7553A. Specifically, Your Honor, I think that, like, when you're looking at these, whether or not there'd be conditions that could satisfactorily protect public and guarantee public safety, there's definitely conditions here, Your Honor. There's no doubt in mind. One of the issues I just want to get to quickly is they were talking about my client having maybe a mental illness of some sort, and that was being taken in, and looking at it, there is not enough information for a court to rely on that, and to be like, well, the court put a lot of weight on that. It was like, well, because he might have this mental illness, we don't know what he could do or the validity of him, and it's undiagnosed. Well, then if you hold him pre-trial, Your Honor, then he can't get any services. And if that's an actual real concern, releasing him and obviously there's conditions that could cover that. You would just say, go to a mental health screening, follow recommendations, and then on top of that, we can connect pretrial services to that, and then he reports directly to pretrial services, and they let the court know if he's complying and following through without violating his confidentiality, and allows him to get the resources he needs. The fact that the court felt like there was no conditions of release is I think is somewhat ridiculous based on the fact that he has no criminal record. He has a really good job. He has a condition for adults that are invested in making sure that he's covered 24/7. And if you read the transcript, Your Honor, you can see how invested and how hard these guys would work for that. Diana, the one he's mainly staying with, got rid of all of guns, weapons, pocket knives. She bought an electrical digital safe to put her car keys in. It has a security system on the house. I mean, there's all these factors that they have to guarantee that public safety is going to be satisfied. And it's only reasonably satisfied, Your Honor. It doesn't have to be guaranteed 100% that there's going to be no possibility of any issues. So the conditions of release, and we also asked for bail, Your Honor, and if bail was imposed, he qualified for home detention. Home detention then gives DOC involved, which gives them a whole bunch of resources. They can come and do a home inspection. It has to be done.
How could a court impose bail in this situation if he has no criminal record, no failures to appear? How would a court even impose bail in this case?
I think that the court can impose bail in regards of if the court was thinking that they need some more. Because this is, to be honest with Your Honor, if we get bail, I want to apply for home detention. I think that's a better place for him. I think that makes the most sense. If the court's really fearful of him violating his conditions of release, but at the same exact time, he has no criminal record, there are conditions that can satisfy him, I would just say that I think that the court made a mistake. I think that this court could find that there are conditions of release that would satisfy GPS monitoring, scram monitoring, daily check-ins with the police. These are all valuable ways that we could make sure that he is satisfiedly being supervised and public protection is reasonably being protected, Your Honor. I yield any further time that I have for a rebuttal.
Okay. All right. Then we'll hear from the state. Attorney Byford.
Thank you, Justice Carroll. First, I'll outline the facts of the case a little bit since we are going de novo. This is a situation where the defendant is charged with burglary into an occupied dwelling for going into his ex, Amber Brooks's home. He actually had been to the home earlier that night and then left when she asked him to leave. She was there, I believe, with her boyfriend. And then he came back again later in the night into the early hours of the morning, banging on the door. When she refused to let him in, he came in through a window in the bathroom, armed with a firearm that did have some ammunition in the chamber, had some ammunition. He's also charged with aggravated domestic assault for pointing that firearm at Miss Brooks and threatening her life. He's also charged with reckless endangerment and criminal threatening arising out of those same facts. These two people have had a very tumultuous relationship. The relationship ostensibly ended in May, and Miss Brooks actually wasn't the person who called police. It was her daughter after the defendant had left, and I think she was upset or whatever, and so her daughter called police for her. The state's position is that this behavior is extremely violent, extremely worrisome. It poses such a threat to the public that there are no combination of conditions that can reasonably ensure safety for the public or for the victim, Miss Brooks. The defendant at various times pointed the gun at her, at himself, indicated that he was going to shoot himself. At one point, the gun actually clicked, but did not obviously fire. He also intimated that when she said she was calling police, that he would be happy because then he could end it by essentially suicide by cop by engaging a law enforcement officer and having them shoot him. He told Trooper Gallup, although he denied pointing the weapon at Miss Brooks, he essentially acknowledged many of the facts, and one of them being that he traveled quite a distance to get to her home in the middle of the night with a firearm. He also confirmed that he still was having suicidal ideations while he was speaking with Trooper Gallup. As far as a mental health issue, Trooper Gallup actually had called mental health and had him screened, and it's in the transcript that mental health had intended to do an EE unless Mr. LaFountain was incarcerated that evening. So the responsible adults, at least two of the proposed responsible adults, two of them indicated that they were aware of some form of mental health crisis, or certainly no one mentioned a diagnosis. There is no evidence of a diagnosis, but the behavior and the escalating behavior over time was documented both by Ms. Brooks in her statement to police, as well as her written statement in Exhibit 2, and I'll get to that in a minute, as well as speaking to the I believe the ex-wife, who may have opined that he was suffering from seasonal affective disorder, and Mr. Hawkins, the defendant's brother, who said that he did acknowledge that he was struggling, but he never, predicted this kind of behavior. Mr. Hawkins also saw the defendant shortly after the incident, where he turned the guns over to Mr. Hawkins, defendant did, and he noted at that point that he was very distraught, and that he didn't get into too much, but he knew that he had been over there with the firearm, and I think he said something to the effect of did not very nice things, or some euphemism without giving any details. So there are concerns that there was some kind of mental health break here, whether it's someone who is in treatment but maybe stopped taking their medication, or whether it's some fresh thing, or maybe it's just a product of the breakup. But for whatever reason, there are concerns about that. As far as State's Exhibit 2, the statement of Ms. Brooks, clearly there was an error there in the notarization. For some reason, our notary put March 11th instead of October 11th, but Ms. Brooks had the correct date when she signed it, and the correct date was on the front, and it was sworn to. And I'll also point out that law enforcement agencies aren't held to the same standard in terms of notarization as civilians. So I do believe that the affidavit comports.
Attorney Byford, you have 5 minutes remaining.
Thank you. So I believe that State's Exhibit 2 does comport with all the requirements of a sworn statement, and there's quite a lot in there about the couple's history that is probative, and I do believe it should be credited. As far as the condition 4, the court's finding that notwithstanding the suitability of the number 4 responsible adults that were proposed, that there was no combination of conditions that would ensure safety to the public or Ms. Brooks. The analysis is basically to go through the 7553A. In this case, the court did that, and then it went through the 7554 factors, and that's all in the transcript. And in terms of the court's verbiage about whether the number 4 custodians could prevent some kind of plan, should Mr. LaFountain formulate a plan, I don't know that we need to take that literally. I think that goes back to the court's fear that the evidence of guilt is great, and that the having made that decision, he doesn't see that any kind of not calling the number 4 custodians jailers or asking them to physically get involved, but that there still would be a public safety concern. Now, of course, if this were under 7553, then he wouldn't have a right to bail, and the presumption would be switched, and we wouldn't have to go through all these factors. But in either way, there's discretion, but it's very broad, very narrow discretion, and the court really thoroughly went through the factors, and even if, again, 2 of these individuals were aware of some kind of mental health issue and were aware of the tumultuous relationship between Ms. Brooks and the defendant, and yet no one ever tried to get him help or do anything that could have prevented this kind of incident from occurring. And I guess at that point I'll reserve for any further time. Thank you.
You can't really reserve because you're the appellee, so if you have anything more to say, you should do it now.
Okay, I will. Well, so I just think if the court takes a good look at the record, the fact that Ms. Brooks was unable to be free of the defendant, even though they had broken up since May, and the concerns, even if we discount any of her statements about him threatening her life, there are statements where he to police that he intended to end his own life, and the number of firearms that were given to Mr. Hawkins, who lives very close by, and did say that he was going to secure them, but all these people live in close proximity. There's no plan is foolproof, and we certainly aren't expecting these people to be jailers, but it does seem that the defendant's fixation on Ms. Brooks and on his own ending his own life raised enough concern that the court's finding for a hold without bail was appropriate. That's all I have. Thank you, Your Honor.
Okay, thank you. How much time does Attorney Handy have remaining?
34 seconds remaining, Your Honor.
Okay.
Your Honor, I'd like to read a quote from Ms. Byford during the hearing. These are great conditions. In the best of all possible worlds, I would agree that this is probably the almost foolproof. So I would say that, Your Honor, even the state agrees that the conditions were foolproof, that the responsible adults met the standard, and that would be responsible and be capable of doing it. I think the court abused its discretion. I think this court can find that there's definitely conditions of release that could do it. He has no criminal record, and if you put bail on it, Your Honor, I'll do the home release and home detention, and I think that will be a great place for him. Thank you, Your Honor, and I really appreciate the time. This was a great experience. Thank you.
All right, thank you both. The bailiff may call a conclusion to the case.